When do a school district's employment decisions violate Title VII's prohibition against racial discrimination in employment? Where is the line between interpersonal conflict and impermissible retaliation? What happens when local politics run amok in a school district?
Yep, folks, it's mayhem. Politics at its best, or worst. Cats and dogs living together. Mass hysteria. Well, maybe it's not that bad, but still, the case we're going to talk about today has a lot to it.
A lot. It's a fun one.
Yeah, it's a good one. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I've been a middle school math teacher and a principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership working to empower folks to better understand and navigate the laws that profoundly impact our schools. This is the show that tells the fascinating stories connecting the courtroom to the classroom.
In today's episode, everybody, we're going to talk about a rather complex case with a ton of history to it. While this is primarily a case about a principal whose contract wasn't renewed and who claimed it was for discriminatory and retaliatory reasons, there's a lot more to this case. Now, you may remember some news from about 15 years ago or so about a Mexican-American studies curriculum that was banned out in Arizona. Well, years after that controversy, the contract of one of the educators who was involved in its creation was not renewed by a school board who had some members who were kind of publicly opposed to the program.
Ooh, okay.
Yeah.
I think I see where the politics is coming in.
Yes, exactly. So today we are heading out west to Arizona to talk about the case of Romero versus Tucson Unified School District. This case is super interesting. So in just a second, we'll dig into it.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Chris, before we dive into today's case, have you got a bell ringer for us?
I do. I've got an update on the ongoing curricular wars, which is a phrase that I just coined, I think. I don't know. I feel like I just came up with it.
Yeah.
Anyway, New Jersey's governor, their Democratic governor, Phil Murphy, recently signed into law a new law that prohibits public and school libraries from banning books in the state. So this is a ban on book bans.
So you could say it's a book ban.
It's a book ban. Yeah.
Ban. Okay.
Oh, Flintstones. I like it. Okay.
Yeah, you like that?
Yeah, that was good. So this happened in December of 2024. The new law bars libraries from excluding books because of the origin, background, or views of the material or the author. It also prohibits censoring books solely because a person finds them offensive.
So isn't that kind of very similar to what the Supreme Court has already said about censoring books, like what is and isn't permissible? Isn't this law just kind of like reiterating what the Supreme Court has already said?
Kind of, though it goes a little bit further, I think.
Okay.
So the Supreme Court in, what was it, Pico versus Island Tree, they basically said you can't remove books for like purely partisan or ideological reasons.
Yeah, just like if you disagree with the content.
Right.
Yeah.
And, you know, that kind of aligns with like Hazelwood, where you need a legitimate pedagogical purpose. But here, I think the law goes a little bit further than that by, you know, kind of expanding those protections. And also the law does two other really important things. It says that school districts have to have policies and procedures in place for collecting materials, shelving materials, and then how to deal with challenges to those materials. So like it requires you to have procedures. And then two,
which many districts already have.
100%.
Just
whether they are aligned with this law or not.
Yeah.
Now you have to have them. And
okay.
It gives you some like kind of baselines for what those have to do. Okay. But the other thing that I think is really important is the law also forbids or offers protections against civil and criminal charges for librarians who comply with the law. Meaning that if these librarians follow this new law, they can't get in trouble either criminally or civilly, like with fines or anything like that. And that's a big deal because a lot of states during these like struggles over the curriculum and what is or is not appropriate for kids have imposed harsh penalties or even criminal sanctions where like librarians could be charged with crimes because of the books that they make available to students or young people. And so New Jersey is joining a couple other states now to basically say like, hey, if you follow this law, librarians, you're not going to get in trouble. We're going in completely opposite direction of these other states and making it so that, we can't ban books. So like New Jersey, Illinois, Minnesota all have laws like this now. And the law itself, like it does carve out exceptions for things like developmentally appropriate materials. So even though you can't ban a book because of its origin, background, or views, you can still like remove a book based on whether you think it's right for that age group. Right. So like there's still this very developmentally appropriate language in
component.
There. Right. Which has been kind of like how other states, particularly more conservative states, have used that to really kind of that idea of developmentally appropriate to really go after books that include racial or LGBTQ themes.
Okay.
So it's interesting to see New Jersey saying, well, you know what?
Yeah.
You guys are going that way. We're going to go this way.
That's fascinating.
It is. It's an interesting little new wrinkle.
Yeah. Can't wait for somebody to challenge that one. See how that plays out.
We'll cover the lawsuit when it happens.
Absolutely. That's what we do here, folks.
We're not going to be out of work.
No. Yeah. So speaking of covering lawsuits, let's cover one from Arizona. How about that?
Let's do it.
Okay. So let's set the stage here a little bit. First, let me just say that this case has so much nuance. All right. And it's got a lot of history. At its heart, this is a political fight between some deeply held interests with lots of history. There's lots of mudslinging. There's lots of he said, she said here. Right. And we're going to do our best to stay true to what the court reported, but we're going to provide a little bit of additional context that we researched and, things that were backed up by the district's records. And, if, for example, somebody claims that something was said in an interview, like we went back and found the interview just to make sure that, it wasn't just he said, she said kind of thing, right?
Right. Yeah. This one's an interesting one because it was very widely reported and it's part of a much bigger like political drama.
Exactly.
Obviously, not all of that's going to be relevant to the court case, though, right?
Right. Yeah. So, like in many cases, we just kind of have to stick to what's in the court record. But, because there's not a lot of other stuff out there to provide that context. But in this case, there was quite a bit. So,
and it's all fun.
It's all very interesting. So let's dig into it. So we're in Tucson, Arizona. And this case centers on Augustine Romero, who worked in the Tucson Unified School District from 1996 to 2018. So
what happened in 2018?
Well, he did not work there anymore.
I think that's going to be the subject of the episode.
It absolutely is. But that's a long time, right? 22 years.
Yeah.
And so during that time, he held a lot of different positions within the district. He had been a social studies teacher. He was the director of the Mexican American Studies department. He served in various other administrative roles, including director of student equity and director of multicultural curriculum. And he served as principal of Pueblo High School from 2014 to 2018.
Wow.
So This guy,
that's a lot
he's
of
had
hats.
a career. Yeah, he's had a career there.
Now, you mentioned the Mexican American Studies program.
Yes.
I've heard of the Tucson School District's Mexican American Studies program, because that was
many of us have.
Yeah, that was a big deal in like what, 2010, 2011.
Yeah, 10, 12, somewhere around there. And what was going on with all of that in this district was national news. Right.
Yeah, because and so Romero was the director of the Mexican American Studies program when all this was going on then.
So I believe so, yeah.
Okay, yeah. So because like in 2010 or 11, there was a big fight in Arizona to basically ban ethnic studies, but it was targeted specifically, if I remember correctly, it was targeted specifically at like some experiences that some state lawmakers had with the Tucson program specifically. And so like, they passed this law, HB 2281. I remember this because this was literally my writing sample for my PhD program. Yeah. Like, so I know a lot about
intimately familiar with this. Yeah.
It was one of my motivations for going to law school.
Oh,
yeah. Because I was like, I wanted to understand what was going on here.
So we're doing this case for you, Chris.
We should do so. Thank you. But HB 2281, so it banned, people called it an ethnic studies ban, but like the CRT bans of today, it never said ethnic studies, right? It said you can't have a program or course of study that like promotes ethnic solidarity or promotes the overthrow of the United States government. It said stuff like that. And so in many ways, it's kind of a natural precursor to the CRT bans and the other curricular gag orders that we've talked a lot about.
Yeah.
And, it ultimately got challenged in court, and a court found that it was racially motivated when they passed it because it was discriminatory against Mexican American individuals.
One of the reasons is because there were other ethnic studies programs taking place, and none of them were affected by all of this. It was just this Mexican American Studies
which
program.
Is the only program in the entire state that ever got targeted by the law.
Yeah.
Which, if you're talking about intent, maybe problematic.
Yeah.
Especially because I think they had like African American studies at Tucson, right?
Yeah.
Like,
yes.
Whoops.
Yeah. So, anyway, that's, that's a little bit of background. All of this is sort of taking place within the context of this controversy that's going on with this state law.
Right.
Which, like Chris said, was eventually ruled unconstitutional about 5 years later.
Right. And we should cover that case too.
Sure. That sounds good. Okay. So we've got this guy, Agustin Romero, and he's done a lot of stuff. He was head of this program, head of the Mexican American Studies Department when all of this stuff was going on. And while that was all taking place,
I imagine there was some difficulties navigating that from within the district.
Yes.
That's got to be a tough position to have for Romero.
That it was, because we've got a couple of board members on the Tucson School Board, Mark Stegeman and Michael Hicks. Okay. And they were both very strongly opposed to this program, and they were strongly opposed to Romero's role in it. And they were very public about that opposition.
Okay.
They gave news interviews, and they even testified against the district and the Mexican American Studies program at the Arizona State Legislature.
Oh, wow. So they
these guys were not happy. Yeah, with this program.
Oh, yeah. Testifying against their own district's program.
Yes.
Okay. Yeah. So there's no bad blood then. It was all water under the bridge.
Yeah. Right. They even called Romero a radical.
Okay. Yeah. Good.
Good. Yeah. Bad blood is probably a good way to kind of describe this.
And we can keep our Taylor Swift references.
Oh yeah.
Streak going.
Look at that.
Yeah.
There. Okay. So after all of this, hullabaloo, that's a legal term.
Hey, I'm here for it.
Romero becomes the principal of Pueblo High School in 2014. All right. He received good evaluations. He was well respected as a school leader. There were a couple of incidents here and there during his leadership that resulted in a couple of investigations, but those investigations essentially determined that, nothing improper took place. So like, for example, one of those things was somebody accused him of improperly changing students' grades.
Oh.
Which sounds like it could be a very bad thing, but
depending on why you do it, right?
Depending on why you do it, but that is technically within the purview of a principal, is to ensure that's to determine whether or not students can matriculate from one grade to the next.
Okay.
And so there were some grades that were changed in order for a couple of students to be able to matriculate. And, just for a little bit of context, there was a substitute English teacher who assigned grades, and those were the grades that the principal modified. We don't know why exactly, but the bottom line is that's within the principal's purview, and the investigation didn't produce any evidence of wrongdoing there.
Okay. And I think that's a really important point. So but with something like this, like a principal, that's I want to call it a political position, but there's politics involved with being
Absolutely.
a principal, especially a principal who used to be head of the Mexican American Studies program that was part of a very national, public, not controversy, but there was a lot of conflict around that. So here you can see how there might be even though if there's no fire under this smoke, the smoke itself
might cause somebody who might not like what that person has done to claim that there is a fire.
Right. And we don't know.
We don't know.
We don't know. Right.
We don't know. Yeah.
That's just kind of what we've.
Yeah.
We're going on from the court records.
Yeah. And so I think, the big takeaway here is, principals and, the stuff happens all the time. And I think the big takeaway here is that the investigations into these allegations didn't prove anything. Okay. So what happens every single year is principals' contracts come up for renewal. All right. And it's the same process every year. And so starting in 2015, I guess, Romero's contract was up for renewal. It got renewed every single year. And we get to the 2017-2018 school year. And the newly appointed superintendent recommends to the board that Romero gets approved for another thing. So basically, after years of getting good evaluations, being well respected, like we said, and even after these allegations of potential wrongdoing or whatever, that sort of amounted to nothing. After all of that, his contract kept getting renewed, and the 2017-2018 school year was no different.
Okay. So the superintendent recommends
forth
Romero to the board. Board votes to
approve him.
Approve it. Okay.
Right. And let's keep in mind here that the folks who were opposed to Romero back when all this Mexican American Studies stuff was going down, Stegeman and Hicks, they're still on the board.
Yeah.
Okay. So they are approving his renewal every year. All right.
Okay.
So until 2018.
Yeah.
Everything goes down. So things take a turn in Tucson in 2018.
Ooh,
like that.
I like that a lot. Yeah, that's good. You should be on radio.
I have a face for it. So
why are we doing a video podcast?
I know. We're sorry, folks. Just close your eyes. So this newly appointed superintendent in 2018 in February declines to award Romero this $10,000 annual stipend that he had been receiving in previous years. Okay.
Ooh, okay.
Yeah.
That's a decent chunk of change.
Yeah. Why do you say? Well, the superintendent told Romero that it was because he couldn't find a record of approval for the stipend.
Which, very important. Don't want to spend money without having
the approval.
Board approval. Yeah.
But it turns out that wasn't actually the reason. The reason was that the superintendent did not feel that the board would approve this compensation request for Romero. because the superintendent obviously is aware of the board members,
right? The board politics
and the politics and the, I guess, disdain for Romero or whatever. And so he didn't put that request up for the board at all, because he was like, why should I bother doing this?
Right. If it's going to get voted down, or it could be one of those things where like you want to stay off the agenda because you don't want to start a fight if you don't have to. Right. So like I can understand the political position that the superintendent is here as well, because at this point,
new.
Right, he's new, and the superintendents are hired by
the board.
So like keeping the board happy is a big part of the superintendent's job.
Well, if the superintendent wants to keep their job.
Well,
I wouldn't say it's their job to keep the board happy, but it's one way to keep your job. Or
that sounds right.
I guess the other way to put it is, the more you tick off the board, the less likely it is you're going to be able to keep your job.
That all sounds right. And because this is a 5-member board, right? And so Hicks and Stegeman are still on the board from when this when the Mexican American Studies stuff all went down.
Right.
And there's this new board member named Rachel Sedgwick, who seems to be kind of joining the Hicks and Stegeman coalition, let's say. Yeah. And now we've got a 3-member majority that,
the other two might be in a similar spot. We don't know, but all we know is that these 3 were not, in favor of Romero and his work and all that stuff.
Right. Yeah. They've got different political ideologies, perhaps.
Yes.
Yeah.
Okay. So he doesn't get this $10,000 compensation for the first time in years. So then 1 month later, in March of 2018, things take another turn.
Of course they do.
Yeah, well, we like it when things take a turn here.
Well, it's one of those things where like every one of our cases is and then. Oh,
wait, there's more.
Exactly. And then someone got so fed up they filed a lawsuit.
Exactly. So for this turn, this time the contract was not put up for a recommendation for renewal. Okay.
Oh, wait. To the board or?
So the way the process works is that the assistant superintendent makes a recommendation to the superintendent, and then the superintendent makes a recommendation to the board.
Okay.
And this time around, the assistant superintendent did not recommend that Romero's contract get renewed.
Interesting.
Why? We have no idea. We don't know. It's not in the record.
Yeah.
So all that we know is that the superintendent ignored that recommendation from the assistant superintendent.
Interesting.
And submitted Romero's name for a board vote.
Okay. So the assistant superintendent said, I don't think we should renew Romero as the principal. The superintendent said, no, we're good.
Yeah.
And then
so when he was asked,
board. Okay.
Right. And so when he was asked why he overruled the assistant superintendent's recommendation, he said, quote, I didn't have any disciplinary concerns about Romero. I didn't have any evaluative concerns about Romero. He performed the function of principal at Pueblo High School fine, as well as I was concerned, to the extent that I made a recommendation for him to continue in the position of 2018-2019, unquote. So at this point in time, the superintendent is stating publicly, I didn't have any concerns about his performance.
Right. Or his evaluations, yeah.
Or nothing.
Yeah.
So I have no reason not to renew him.
No red flags, according to the superintendent.
Exactly. So what happened was he was renewed.
Oh, wait, in 2018?
He was.
Okay.
Don't worry. There's another turn coming.
Oh, okay. And wait, there's more.
And wait. So they voted to renew his contract along with a whole bunch of other administrators' contracts, sort of in one single action item, so that they, I guess, so, for the sake of efficiency.
Efficiency, for sure.
So that lump approval process was passed 3-2 with Sedgwick and Stegeman voting no.
Okay. Oh, wait, that means that Hicks voted yes to renewing Romero. And Hicks was on the board during the Mexican American Studies stuff.
Hicks was very against Romero. And so this all seems very strange.
That does seem odd. But it's one motion for all of the administrators or a ton of the administrators. So like Romero is just one name amongst many.
Yeah.
Okay.
But, Hicks votes yes, and everybody gets rehired. But a couple of days later, Hicks goes onto a local radio show and things got very interesting.
Okay.
So he was asked about that vote, and he explained that he voted to renew Romero's contract because the superintendent's recommendation and because of some agreements that some disagreements that he was having with Sedgwick and Stegeman.
Oh.
So now this trio seems to be, potentially
there's some tension in paradise.
Tension there.
Yeah.
Right. And so he was asked point blank in this interview if he thought that renewing Romero's contract was good for the district. And he was quoted as saying, "I don't think so, but that's the superintendent."
Oh.
So it sounds like he was like, listen, that's not the superintendent does his thing and my job is to rubber stamp him, I guess. I don't know.
Or like he's the expert on school personnel. So,
So who am I to say?
Yeah. Who am I to second guess that? Right.
Yeah.
And I think there'd been a history in the district of like basically accepting the superintendent's administrator recommendations.
Yeah. So he goes on to say, why do we hire a superintendent?
Wait, this is Hicks, the board member?
This is Hicks, the board member. Why do we hire a superintendent? Why doesn't the board just run the entire damn district? We don't need a superintendent. We don't need any of them. I can tell you that if it had gone down the way it was supposed to go down, Romero wouldn't have a contract.
Wait a second.
Yes, let's go on the radio and say that.
Yeah, we need to unpack that. Oh, geez.
Do we really? I think it speaks for itself, man.
My attorney brain just went crazy. Number one, I don't think this board member knows what goes into running a district, because I don't think any board would willingly want to run a school district.
God.
But two, obviously this indicates some tension between the superintendent and the board, right? But that line, if things had gone down the way it was supposed to go down, that seems to me that
I thought it did go down the way it was supposed to go down.
Right. Well, it sounds like Hicks, Stegeman, and Sedgwick had some sort of plan about how it went down, and the other two didn't follow the plan. So Hicks didn't follow the plan. It feels like you might have violated some open records laws and open meetings laws, because
that's possible. But I also think that, maybe it could have been as simple as him just saying, the superintendent shouldn't have passed on that recommendation because the assistant superintendent did not recommend it. Who knows?
Right. Yeah. Just reading into some of the politics of it. But at the very least, that is a veiled threat at the superintendent, right?
Yeah.
Why do we need you?
Yes, exactly. It's messy.
Yeah.
So speaking of veiled threats, after the interview, Sedgwick said, "I am surprised that Michael Hicks would use his influence not to help, but to spite Mark Stegeman and me. I believe he may be on the ballot in November if he collects enough signatures."
Oh,
I'm thankful for that, at least.
So here you have another board member coming and saying, "Hey guys, this guy's going to be up for re-election, and he went against me and Stegeman, so maybe we should vote him out." Is that the level of infighting we're at?
I don't know, but I think it's very clear that there's plenty of infighting going on.
Yeah. Politics run amok. Yeah. Cats and dogs living together, as you say.
Yeah, exactly. Right. It's mass hysteria. Thank you, Ghostbusters, for that. Bill Murray, great line. So after those interviews, Hicks requested that Romero's contract be added back to the agenda for the next board meeting. So why did he do that? I don't know. Cat's out of the bag now. He's gone on record saying, "I don't agree with that decision." So
then why'd you vote for it?
Yeah.
Then why'd you vote for it? Maybe he needs something. Yeah.
Yeah. Anyway, doesn't matter. At the next board meeting in April, the board considered Romero's contract by itself, and Hicks, Stegeman, and Sedgwick voted to rescind the renewal and notify Romero that his contract would not be renewed for the next school year.
There it is.
So they took it all. I take it all back.
Yeah.
All right. So this caused a lot of stuff in the community. It was public.
I'm sure.
It was a big stir, right? There's already this public back and forth between Hicks and Sedgwick.
And some other board members.
Other board members. There was another board member who told a news outlet that Stegeman and Hicks had been very opposed to Romero, beginning with the conflict over the Mexican-American Studies program. So like, this has been bubbling for years, right?
Right.
And Romero was not totally quiet with all of this himself.
Well, yeah, he had just gotten not fired, but non-renewed, right?
Yeah. So he speaks to the media and he says that the board, quote, has a history of racism and that the board is racist.
Oh, okay.
Yeah. Yes.
Yeah. So definitely not taking this quietly.
No.
Okay.
And just to round out what's going on here, there were multiple reports from other board members and staff members from the district that, between 2017 and 2019.
So during this time.
Yeah. During all of this, there were a number of reports from board members and staff members that this was an incredibly oppressive environment. There's a lot of intimidation going on. A lot of that was coming from Stegeman and Sedgwick, according to these reports. The morale was horrible, feelings of anxiety and fear. People were trying to stay off the radar of certain board members. Staff members were crying all the time. It was very stressful. Dogs and cats living together. It just sounds like it was a highly dysfunctional, toxic kind of environment.
Right. That stems from this like politics.
Yeah.
Or I guess this disconnect between some of the educational goals and some of the politics that was going on in the school board and in the state.
Right. Exactly.
Okay. Yeah.
So here's where the kind of the crux of the lawsuit comes in, because everything we've given you so far is just context, because the lawsuit is only about why Romero was not rehired when he applied for other jobs after he was his contract wasn't renewed.
Right.
So,
which is really interesting. That
none of this other stuff is part of, no defamation, no, anything like that.
Wrongful termination or any of that
Wrongful
stuff.
termination. Yeah, nothing. So after the contract was rescinded between 2018 and 2020, Romero applied to 7 different administrator positions within that district. So after all of this stuff went down, me personally, I'm like,
kudos for him to still wanting to work. Yeah, I mean, he'd been there for 22 years, right?
Yeah, exactly.
Yeah.
So he applied for 7 different positions. The district and Romero both agree that every one of those jobs he applied for, he was qualified for. Okay. And he got through the initial screening process for all of those jobs. And he received an initial panel interview for all of those jobs. However, that's where it stopped. He never made it to a finalist interview with the superintendent. Okay. For any of those positions. There's some conflicting testimony about how much influence the superintendent had over this whole process. He said he didn't have very much influence over the initial screening and the panel interviews, but a staff member testified that he was deeply involved. Why does this matter? Well, the interviews were scored and Romero received scores that were lower than the finalists for each of the other positions.
Okay.
So there were concerns about fairness here.
I was going to say, I was expecting a but there, because if he wasn't the best candidate, then I guess, that might explain why he wasn't hired.
Yeah.
But if this superintendent, who we're already kind of talking about the relationship between the superintendent and the board, like if he's got political reasons for what's going on, maybe there's something else going on here, right? Yeah.
And again, he said, listen, it's not me. I didn't have much influence over this process. And somebody else, a staff member, said, that's not true. He had big influence over it.
Right.
So the executive director for HR at the district recalled a conversation that she had had with the superintendent. And apparently the superintendent said, quote, "I won't ever let Romero get to the governing board."
Oh, no.
Yeah. I don't know if when that director asked him what he meant by that, he said that he wasn't happy with Romero's performance as a principal and that he would not move Romero's name to consideration for those higher level positions.
But he put him up for renewal because there were no red flags and he was happy with his performance.
Yes.
He said that.
Yes, he said specifically, I didn't have any disciplinary concerns about Romero. I didn't have any evaluative concerns about Romero. He performed the functions of principal at Pueblo High School fine, as well as I was concerned, to the extent that I made a recommendation for him to continue. And then he applies for these other jobs.
And now suddenly,
and now says
he's not happy with it.
He's not happy.
Oh, no.
I wouldn't ever let him get to the governing board.
Right. Which that's a huge, regardless of how much influence he had on the process, that statement by itself seems to indicate that Romero is not getting a fair shake. Right.
Yeah, absolutely.
Ooh.
Absolutely. Yeah. So he didn't get any of those positions and he wasn't happy about it. And he filed a lawsuit.
Hey, that's my line.
Oh, sorry.
So Romero brings this lawsuit alleging that the district violated Title VII by engaging in employment discrimination against him when they refused to hire him back to the district. So we talked about that, right? Why didn't he challenge the initial non-renewal? It could be a lot of reasons. It could be a statute of limitations issue where basically too much time had passed. So he couldn't bring that lawsuit anymore. We don't know. It could be a strategic reason. Not 100% sure, but he's challenging them not rehiring him.
Okay.
Yeah.
Okay.
So Title VII, just to kind of take a step back a little bit, this is the federal statute that prohibits employers from discriminating against employees based on race, color, religion, sex, or national origin.
Okay.
And so Romero's alleging here that the district discriminated against him because he is Mexican American, and they're retaliating against him because he spoke out against the district, and that's why they're not hiring him. So when he called the board's actions racist, right? Basically they're saying they don't like me, and they don't like me because I called out their racist actions.
Okay.
Which is, based on race. So that kind of racial retaliation is covered under Title VII.
Okay. Gotcha.
So the lawsuit works its way through the process. Jamie, you're probably disappointed to hear this is not a 12B6 motion to dismiss.
That's too bad.
We get further along than that this time.
Well, the upside to that, though, if we get further along, is we get discovery, right? Which means both sides get to kind of tell their story.
Exactly. So we have discovery. So, discovery involves you trade documents, you depose witnesses, which basically means you sit them down and you do interviews. Yeah. And so after they do all of that, they close discovery and the school district moves for summary judgment.
Okay.
So summary judgment is the school district says we don't need to go to trial because even if you make all of the factual inferences in favor of the other side, in favor of Romero, we still win as a matter of law. So
it's very similar to a 12B6.
It's very similar.
It's just more information has come out before the school district in this case says it doesn't matter. Even if you take their version, we still win.
Not exactly.
No.
It's we agree on all of the material facts, meaning that there's not a question of fact. It's not a he said, she said anymore. It's no, this is the universe of agreed upon facts. There's no question here that's related to the outcome of the case. So based on those agreed upon facts, even if you make inferences in favor of the other party, we win.
Okay.
Gotcha. So it's a little different, but they're very
so the
similar
school district. Yeah. So the school district in this case is saying, all right, everything has come out. We agree. We don't disagree with anything that they said there in all their information.
Yeah. Based on the undisputed facts, we think we win.
Yeah. Okay.
So we've got two claims here, right? We've got two claims under Title VII alleging employment discrimination. Now, there's a few ways to establish racial discrimination under Title VII. You can point to facial discrimination. This is where someone flat out comes out and says, I'm not hiring you because of your sex. I'm not hiring you because of your race.
Okay.
Most cases aren't that cut and dry, obviously, right?
And this one really isn't either.
It isn't either. So we've got to look for circumstantial evidence, right? So if we don't have just direct evidence of discrimination, then we look to what's called the McDonnell-Douglas test. And this is very thoughtfully and creatively named after the Supreme Court case where they established this test, which was McDonnell Douglas Corporation versus Green.
Okay.
We lawyers are nothing if not creative.
Yeah, right.
So under McDonnell Douglas, and we use this when we're looking for basically, was race or, membership in a protected class, like, was that the justification for a negative employment action? And if the answer is yes, then, obviously you violated Title VII. So there's a couple. McDonnell Douglas is a burden shifting standard. So the first thing is that the plaintiff, the person alleging that they were the recipient of, or they were, subjected to discrimination, they have to prove what's called a prima facie case of discrimination. And so basically what this does is it looks at, the circumstances, and it asks whether or not there's a presumption of intentional discrimination. So we look at everything to see if possible racial discrimination played a part in the employer's decision.
Okay.
If we establish that, then the burden shifts to the employer to come back and say,
no, it wasn't.
No, it wasn't. We've got these legitimate non-discriminatory reasons for doing what we did.
Okay.
So, we didn't do it because of their membership in a protected class. We did it because they were bad at their job. They broke the rules, whatever it might be.
So I would guess at this point that the court would look at everything and say, yeah, that's actually possible. And the school district would need to turn around and say, and actually prove that, no, we didn't do this for, retaliatory or racially motivated reasons. Right.
Yeah. And that's kind of, to preview what the court does is it kind of looks at this and says, like, yeah, for some of these, there's a prima facie case because, the circumstances here are a little fishy.
Yeah. He's done a great job. We're going to hire him back. All of a sudden, nope, we're not going to hire him for anything else because I had major concerns.
Right. And also like the renewal and then the rescinding the renewal, like there's a lot of funky procedural things here, which if you deviate from procedure, that's usually, that is one of the indicators that something fishy is going on.
Yes. Another legal term. Yes.
Yes. Yeah. Something fishy. I know it when I see it. Yeah. We're creative and precise.
Exactly.
So the last thing in the McDonnell Douglas test is if the employer does demonstrate a legitimate non-discriminatory reason for the action, for the negative employment action, then the employee gets an opportunity to prove that justification is really just a pretext for discrimination. So basically, the employer is just trying to cover up their true reason, which is discriminatory intent, with some fabricated excuse. It's something that they came up with after the fact just to justify their desire, their intent to discriminate.
So basically the simple version of that is that the employee has the opportunity to call BS on their reasoning.
Exactly. That's 100% it. Right. Yeah.
Okay, great.
I don't know why the Supreme Court didn't write it that way.
You know what? I'm not on it.
I was going to say they should put you on the Supreme Court, Jamie.
I do not meet the minimum qualifications.
I don't think you have to be an attorney. There have been Supreme Court.
Wait, I actually don't know what it takes to really, like, is there any, are there any?
One
like,
of
you just
my,
have to be voted by
you have to be confirmed by the Senate. One of my favorite justices. Well, no, now I'm blanking on.
It doesn't matter. I won't do it.
Justice Jackson. So Justice Robert Jackson, who was confirmed on the Supreme Court in 1941. He is the most recent U.S. Supreme Court justice who did not earn a law degree.
Oh,
but he was admitted to practice bar through a traditional internship. So he was a lawyer. He just hadn't gone to law school. So
all right.
There's hope for you yet, Jamie.
I don't want it. I don't want it.
Jamie, you and I have already started to talk about like how the McDonnell Douglas framework applies to Romero's claims. So remember, we've got these two claims. We've got the discriminatory impact claim, which is basically saying like, you treated me worse than other folks who are not Mexican American. And then we've got the retaliation claim. And all of this is based on the decision whether or not to rehire Romero back to the district.
Okay.
So in the context of the failure to rehire him, based on his membership in a protected class. In order to demonstrate a prima facie case here, Romero has to show that he met the qualifications, that he suffered an adverse employment action, and that people outside of his group were treated more favorably.
Oh, so
and he hits the first two, right? Like,
yeah, so
he was qualified. Everyone agreed.
Yeah.
Wasn't rehired. That's a negative employment action.
Yeah.
But there's no evidence here that people who weren't Mexican American were treated more favorably than he was, because
were there some Mexican American candidates that were?
There were a significant number. So of the roles that Romero applied for, 40% of the individuals hired were also Hispanic.
Oh,
so
well, then that doesn't really satisfy that prong of the test.
Right. So like that definitely shifts things in the district's favor. Right. You can also point to like circumstantial evidence that, like, you know, maybe I wasn't treated worse than other folks of my race, but like they singled me out for special treatment.
Right. Right.
And here there's no like circumstantial evidence of racial discrimination or national origin discrimination, because, like, you know, it's very clear that Hicks and Stegeman strongly opposed Romero, but their objections weren't necessarily based on, according to the court, weren't based on race or ethnicity. They were based on kind of political differences, right? Romero,
they didn't like his program. They didn't want the program. They had problems with the program.
Right. But that raises a question for me, because the program,
and they called him a radical, which is not a racist term.
Right.
Necessarily.
Well, necessarily. Right. But Romero was calling the board racist, right?
Racist. Exactly.
But like the program that the board members are objecting to is a Mexican American studies program. So like race is so baked into this thing.
Yeah, exactly.
That like, to me, it's hard to pull that out and say like, oh, well, you know, race had no influence in their disagreement, when like clearly their disagreement is about something that is grounded in race and our understandings of race, right? Like, so, you know, the court doesn't get into that and doesn't address that argument, but the court basically just says there's no evidence here that Romero was treated worse or was discriminated against because of his race, because, you know, there's no circumstantial evidence, and there's no indication that people outside of his racial group were treated better.
Okay.
Right. So that prima facie case, or Romero fails to establish a prima facie case there, and the school district gets summary judgment on this disparate treatment claim.
Okay.
But Romero has his retaliation claim as well. And under his retaliation claim, this is a different story. So to establish this prima facie case for his retaliation claim, which is basically saying like, hey, I spoke back against what I perceived as the board's racist actions, and they retaliated against me by not hiring me.
Yes.
Which there might be a smoking gun here, because the superintendent said, I'm not putting Romero in front of the board to be considered for a new position, a new contract, right?
Right.
So to establish a prima facie case here, Romero's got to show that he engaged in protected activity, that he was subjected to an adverse employment action, and that there's some causal link between the protected activity and the employment action. So protected activity, he spoke out against the board. That is protected. It was based on his, you know,
his experiences
and his position about the board and their motivations for doing what they're doing.
And it was clearly a matter of public concern. Right.
Oh,
I mean,
right.
You know, the board had been very public about all of this stuff. They going on doing interviews and all kinds of, you know, things. Right.
Yeah. So that first prong is absolutely met.
Yeah.
The second one, like, was there an adverse employment action? Didn't get rehired. Right. The tricky one here is this causal link. So basically, like, did he not get rehired because of what he said? Right. And so in law, we call this the but-for cause.
That's fun.
Yeah. Right. So, but for Romero's speech, would the district have rehired him?
Yeah.
Right.
Seems like an unnecessary choice of wording, but
it's old.
Yeah.
And again, I didn't come up with it. So
I'm old and I don't use that stuff.
Well, you didn't go to law school
in the 1700s. Yeah.
Yeah. Right. Okay. This is tort causation. Yeah. No, we don't need to worry about it. So the court looks at this and says, you know what? This is a much closer call. I can't say as a matter of law that this was a but-for causation, or it wasn't. So the court basically says, like, this is a question of fact that needs to go to a jury or to the trier of fact. Because right now, like, we've got enough to say, there's enough evidence here to raise a question of fact whether or not the superintendent or the board were acting out of a retaliatory intent. We've got evidence of these 3 board members creating a very stressful environment. We've got the superintendent's contradictory statements.
Yeah.
We've got all of this, context here that makes it seem like Romero is being targeted because of, potentially because of what he said and like his opposition, let's say, to the board, right?
Yeah. Or his advocacy for things that the board was opposed to. Yeah.
Right. Yeah. And the school board kind of sees that and says, like, even if he does establish this prima facie case and establish that, we were motivated by this intent to retaliate against him for what he said, like that's not really why we did what we did. We did what we did because, we had these legitimate non-discriminatory reasons. Like the assistant superintendent suggested that he be non-renewed. Right. Like we had all these other concerns about, some other things that went on with with his school, with the grade changes or whatever it might be. Like, we've got these legitimate reasons. And Romero's response to this is, well, all of those reasons are pretextual and they're tainted by animus against me because I stood up to the board. So really, you're just looking for after the fact justifications to hide, your real reason, which was to silence me and to get me out of the way. Yeah. So, ultimately, the court says there's a triable issue here and the school district does not get summary judgment on this claim. It's going to go to a jury because Romero didn't move for summary judgment at this point. Right. So like this question. He wants a trial. He wants to go to trial.
He wants the truth to come out, basically. Yeah.
Yeah.
I mean, it sounds kind of silly, but that's exactly what is going to happen or supposed to happen at a trial. Right. Like
exactly. Everyone gets on the stand, swears to tell the truth, the whole truth and nothing but the truth.
And then a jury decides whether or not.
Right. Or the judge, if it's a bench trial. Yeah.
Right. Yeah. Somebody will decide whether, whose stories are more plausible.
Exactly. Exactly. And that's kind of where we are now. So the case is still ongoing. So the district won the disparate treatment claim. The retaliation claim moves forward.
Does that mean, I'm just clarifying, that the trial can only concern itself with the retaliatory claim? Like, it's not going to be addressing the question about the disparate employment action, right?
You'll still be able to bring all those evidence into play because it all explains why the district did what it did. Yeah.
Exactly. But that's not the thing that they're going to be deciding on.
Exactly.
They're not allowed to decide on that because that's already been decided on, right?
Yeah, it's been dismissed, so it's not part of the case anymore. Yep.
Okay.
So something I found really interesting is, while this case is still ongoing, a few of our board members' political careers, at least in the Tucson Unified School District School Board, are not ongoing.
Well, they were around for a long time.
They were, and maybe they just kind of step back. Yeah. But at least one of them tried to continue and lost his reelection.
Lost the election. Yeah.
So Hicks lost reelection in 2018.
So when all of this, right after all of this is
right after Sedgwick's veiled threats about being thankful that he was up for reelection. So those threats maybe weren't so veiled after all.
Yeah. Yeah. Somebody got what they wanted.
Yeah. And then Stegeman actually resigned from the board a year later in 2019, citing that things of the district had moved in a direction that he couldn't support. And so he wasn't the best spokesperson for the board anymore. So he just resigned. And then Sedgwick, for her part, did not run for re-election after her first term ended in 2021. So none of them are currently on the board.
Yeah. Wow.
Yeah, it's a fun one. So we'll have to keep watching this one.
Yeah, we're definitely going to have to keep watching this one. It is, listen, if this case didn't do anything else, it at the very least illustrates how messy these relationships and these political ideologies and these, it can get nasty.
It can.
And it affects people's lives.
And the climate for the school district too, right?
Totally. Having all these staff members saying that the environment was toxic, they were crying and blah, blah, blah. And it's difficult because of the way that these systems are kind of set up. Okay. So we elect school board members, and the job of the school board is to hire the superintendent who's sort of in charge
of the day-to-day,
district, of the day-to-day of the operations and everything. And if the board doesn't like the decisions that the superintendent's making, then that could be the end of the superintendent.
Right.
You know?
Yeah.
And
so there's a lot of politics, right? Like, and that's not even looking at ideological issues, right? And then you toss those ideological differences into the mix, and that's a recipe for some really messy, to use your word, like interactions. Yeah. And like you said, this is kind of a great example of how these kind of political egos can run amok in education when folks have kind of an axe to grind.
Yes. Yes. And listen, there's a good chance that there's a lot of school districts out there that are functioning beautifully, and that the relationships are what they need to be and all of that stuff. But there's also the possibility that if you're listening to this episode, you could potentially be in a district where there's, some dysfunction, or at the very least, some significant differences of opinion.
And people can have significant differences of opinion and have those kind of principled debates and conflicts without resulting in the kind of environment that it sounds like Tucson was in, where there was fear and there was uncertainty and there was retaliation or potential retaliation for you come at me, I'm going to come at you harder, right? Like there's a productive way to have those kinds of disagreements. And I'm not sure if this was it.
Well, yeah. And I think that, that's sort of the last thing that I will say on the topic, is that it is okay to have those disagreements. In fact, it's probably good.
More than
to
okay.
Have those,
it's welcome.
It's because that's the only way we can move forward. That's the only way we can improve. That's the only way we can come to consensus and, all of that stuff. But when those things devolve to such a place where there's infighting and where there's fear and where there's, whatever, I know it might sound cliche to say it, but the people that are going to suffer are going to be the students.
Right.
And I mean, again, I know that sounds cliche, but you know what? That's how this stuff works. If you've got dysfunction, on the board and between the board and the superintendent, obviously that stuff trickles down to school administrators, and building level administrators. And when they're affected by this stuff, then the teachers are affected by this stuff, and the students and parents, community members, everything.
Right.
And you know what? We're not going to be doing what is best for students in those kinds of environments, period.
Right. Yeah.
At the very least, we're teaching them how not to engage with one another. Right.
Which isn't the democratic lessons we want our students to learn.
Exactly.
Yeah, exactly.
How can we be productive members of society and live together and, figure out how to agree to disagree and move on and, do what's best for the community? We're obviously not teaching them, role modeling to them how to do that with all of this nonsense. But anyway, this is a
pretty
good
much wraps it up.
That does. This is a good case, man. So let's take us out. What's our homework?
Your homework is to like, rate, review Chalk and Gavel wherever you get your podcasts. We would love to hear from you. We've got a feedback form on our website, chalkandgavel.com, or you can find us at social media at Chalk and Gavel. You can also find our teaching guide on our website. And if you like what you hear and you want to support the show, you can go to patreon.com/chalkandgavel. $2 a month goes a long way to helping us continue to deliver the education law content that you know and love.
Sounds good. Well, then, everybody, we'll see you again in 2 weeks with another case. Have a good one.